All right. Well, I think I am live right now. So, welcome everyone to this session on employment law. Welcome. My name is Lior Samfiru, but you knew that. I'm the employment lawyer, of course. I'm one of the founding partners of Samfiru Tumarkin LLP. We are the largest employment law firm in this country, across this great country of ours. And I'm here now, as I am every week, to talk about employment law, but more importantly, to answer your questions. This is a live Q&A session where you get to ask me questions about employment law, about severance, about constructive dismissal, human rights, harassment, whatever the issue is. You get to ask me that question. I read it, I answer it, and you have the information that you need. So welcome to this session. If it's the first time, again, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. Let me give you some contact information. If you want to connect with me and my team off social media, you want to have a private discussion, a private email exchange, very, very easy to do that. All you do is you go to employmentlawyer.ca. You see the address below right now, employmentlawyer.ca, and phone number is there, email address is there. For myself and everyone on my team, there's more information to read there about employment law if you want. We have some amazing tools. So it's kind of your one-stop shop for anything employment law. Again, employmentlawyer.ca. But that's for later. Right now, I'm Lior Samfiru, and I am live here for you at your service, answering your questions. So I have plenty of stuff I can talk to and I talk about, and I want to talk about. But much more important than that, you can be the second voice on this session by asking your question, by telling me what you want to know, what your issue is, so that I can answer it and hopefully make you feel better. We have some really good employment laws in this country. We really do. And my job is to tell you what they are, to tell you what those laws can do for you and how to use those laws to your benefit. That's what this session is about. So maybe you're being mistreated at work. Maybe your boss has changed your job or told you your compensation is going to change. Maybe they're relocating you somewhere. Maybe you're not treated properly. Maybe you've just lost your job. I don't know. Maybe you've been put on a temporary layoff. If any of that or anything else sounds familiar, if it's your situation, you have an opportunity to ask me, what do I do? Is this legal? Can my employer do this? All those questions you can ask right now, and I'll answer. So again, my name is Lior Samfiru, the employment lawyer, live here for you at your service. You see that box on your screen. Type in your question, hit return. I'll see it, I'll read it, and I'll answer it. As I'm waiting for your questions, I wanted to talk in between those questions today about wrongful dismissal. I want to talk about exactly what a wrongful dismissal is and how do you know if you've been wrongfully dismissed, and of course, what to do about it. So this is an important topic. It's a topic that comes up often, and it's one that's misunderstood. So I'm going to get to that, but your questions are always top priority. And I have a question coming in. First question of the day is from Bobby on YouTube. Bobby asks, if I have an occupational health and safety case against my former employer in regards to wrongful dismissal, should I wait before I try to retain your office's services? Okay, so occupational health and safety and wrongful dismissal are completely separate things. So I'm not sure exactly what you mean if you have an occupational health and safety case for wrongful dismissal. Those are separate things. Occupational health and safety is a situation where your employer is not provided a safe workplace. That's a government thing. Wrongful dismissal is a situation where you've been let go when you haven't been paid what you're owed. If you've been let go, you need to talk to me and my team, always, 10 out of 10 times. Doesn't matter what the reason is. Doesn't matter the circumstances of them letting you go. Doesn't matter if they say they have cause, they don't have cause. Whatever the situation, you absolutely have to talk to me. Okay, so, but again, occupational health and safety and wrongful dismissal, different things. So Bobby, if you want to tell me more about your situation, I can provide you more information. Happy to do that. But if you lost your job, doesn't matter if you work for 10 years or 10 days, you got to give me a call, always. And to connect with me and my team, I've said that before, I'll give it to you again, employmentlawyer.ca. Again, employmentlawyer.ca. So thank you for that, but I'm still here, Bobby. You want to follow up, ask it. All right, next question. Keep them coming. By the way, I always say this, and it always happens. I always get a bunch of questions right in the last few seconds of the session, and then I don't get to answer them. Don't do that. You have plenty of time now. You're not rushed. Ask the question. Give me that opportunity to answer it, and then you're not going to miss out. Okay, but the next question is from Wayne. Wayne is also on YouTube. If you're on long-term disability and your company stops your medical benefits after 12 months, is that legal? Great question. So the answer is they can do that if they have something, some policy, something written in place that says you can only be on benefits and disability for 12 months. What I mean by that is if there's nothing, they just decided, you know what, 12 months is enough, we're going to cut you off. They can't do that. That could be a constructive dismissal. On the other hand, if it's a term of employment, there's a policy that says you stay on only for 12 months, then they can do that. So if it's always been a term, they can do it. If they just made it up now or they're just doing it now because they've decided to, can't do that. That could be a constructive dismissal, and you can choose to pursue it as a constructive dismissal. Right? So hopefully that helps. And keep in mind, of course, that even if it's legal because they have a policy to cut you off benefits, it doesn't mean that they've let you go. You still have a right to your job when and if you get better from work. So we can always talk about that. So hopefully that answers your question, Wayne. If I missed something, if you have a follow-up, I'm still here. Ask your question. For those that are just joining me right now, first of all, welcome. Welcome to this live Q&A session. I'm Lior Samfiru, the employment lawyer. As you've seen already, I'm here at your service answering your questions about employment law, about workplace rights, about human rights, discrimination, you name it. If it has to do with something between you and an employer, this is the right place. This is the right session to get answers. All right. Next question is from Brent. My supervisor has informed us that our shift rotation will be changing drastically in the next few months. Do I have to accept this? So obviously, I don't know exactly what drastically means in this context, but let's assume it is drastic. Let's assume it's a big change. No, your employer does not have the right to make significant changes to the terms of your employment. That means that, Brent, if your employer says, well, too bad, we're doing it anyway. You used to work days, now you work nights, as an example. You have two options. Option number one is you can accept it. Of course, you have a right to accept it. You can accept and continue working. The second option you have is you can treat this change as a termination. We call this constructive dismissal. And by changing your shift in such a significant way, that allows you to leave, but still get your full severance as if the company actually terminated your employment. You don't have to accept it. You can treat that as a termination, as a breach of the terms of employment. And that means you get your full severance. And depending how long you've been there, Brent, that could be as much as 24 months of severance that you're owed. So if you've decided that you don't want to accept it, if you've decided, no way am I changing my shift in such a drastic way, to use your words, then let's talk before you do anything, before you say no to your employer, before you even respond to your employer. Call me or email me, again, through employmentlawyer.ca. You see that address right there, employmentlawyer.ca. Let's have that chat. Let's make sure we do it right. But for everyone else there as well, very important to remember, anytime you're facing a significant change to the terms of employment, this idea of constructive dismissal should come to mind. So change in pay, change in hours, in shifts, a demotion, even a significant relocation. We're going to spend more than an hour getting to work, an hour more than you did before. Constructive dismissal, that term should come to mind. It's not something your employer can do. Just think about it this way. You couldn't go to your employer and say, hey, employer, I decided that instead of working nights, I'm going to work days. So thank you. Starting tomorrow, I'm working days. Goodbye. You couldn't do that, right? Well, by the same token, your employer can't do the reverse. Your employer can't say, I've decided that you're going to work days and not nights or whatever it is. So your terms of employment are what they are. You can't just decide to change them. Neither can your employer. So that's why this constructive dismissal concept exists. Okay, I'm caught up on questions, and I promise I'll talk more about wrongful dismissal. So let's start. By the way, still waiting for your question, by the way. Ask questions right now. You got time. You got another 20 minutes or so. Ask your questions. Plenty of time to make sure you get answers. But in between your questions, again, discussion a bit about wrongful dismissal. What is a wrongful dismissal? Well, let's start by what a wrongful dismissal is not. So a wrongful dismissal is not necessarily a situation when you're let go for no reason or bad reason. That's not a wrongful dismissal. The reason for that is a company generally can let you go for any reason or no reason or bad reason as long as they pay you proper severance. So you may say, and you may be right, that the company doesn't have a good reason to let me go. I've done everything I was supposed to. I'm a good employee. I have good performance reviews. So why are they letting me go? Or you may say, they told me they're cutting costs, but I know that that's nonsense because they just hired someone else. So they're lying to me. And you probably are right. And of course, it's not a good thing to lie, and no one should lie. But from a legal standpoint, an employer can do that. An employer can lie about the reason, or not give a reason, or not have a good reason, as long as they pay proper severance. Now, of course, there's exceptions to that. You cannot be let go for a discriminatory reason. So, for example, you can't be let go because of your age or disability or ethnicity or sexual orientation. You can't be let go. That's illegal. That's a human rights violation. But unless what the employer doing is discrimination, unless it's discriminatory, then you can be let go as long as proper severance is paid. So the question becomes, what is a wrongful dismissal? Well, a wrongful dismissal then is simply a situation when you've been let go and have not been paid your proper severance. Okay? If you've been let go and you're owed a certain amount of severance and you haven't been paid that or offered that, you've been wrongfully dismissed. That's what it is. So when you hear me talk a lot on these sessions about severance, the reason I talk about severance so often, it's not because that's what I want to talk about. It's because that's what the law deals with. All right. So if you lose your job, the law can't make your employer hire you back. They can't make your employer a better person, a more honest person. All the law can do is compensate you by way of severance. Now, good thing that severance can be as much as 24 months pay. Okay, it's significant. Even if you work for a short period of time, it's still a significant amount. But that's why what a wrongful dismissal is really has nothing to do with the reason. It's all about the severance. I'm going to talk more about that, but we have another question here from Janice. And by the way, you ask your questions. Please, if any of this sounds familiar, or if there's something you want to know or have always wanted to know, ask the question right now. So Janice asks, is it also a constructive dismissal if your commissions are removed? I was hired and agreed to a partially commission-based payment structure. Then that is now being changed to salary only. Absolutely, 100%. So you're salary and commission, and the company says, forget, no more commission, just salary now. That is constructive dismissal. If you are on just salary, and that company says, we're going to reduce your salary and add commission, constructive dismissal. So any significant change to the compensation structure is not something your employer is allowed to do, and absolutely can be a constructive dismissal. Now, your employer may say, well, wait a second, we increased your salary, so we're making up for the loss of commission. No, you didn't, because the whole point of commissions is you have potential to earn more, right? That's the point of commission. So your employer, by taking away that potential and replacing it with a fixed amount, it's still not something that they're allowed to do. That's still a significant change. So yes, Janice, absolutely, that would be a constructive dismissal. So if you're in that situation, your compensation structure, not even necessarily the dollar amount, but the compensation structure was changed. Yeah, we're in constructive dismissal territory, and you need to call me. And definitely, anytime you feel that your situation may be a constructive dismissal, it is vital that you call me. It absolutely is vital. Don't say, well, I know it's a constructive, so I'm leaving. Don't respond to your employer. You can easily compromise your rights without even realizing that that's what you're doing. Okay? So if you believe you've been constructively dismissed, if you're not sure if what your employer is doing is legal, well, no need to wonder, no need to not be sure. Just call me or email me, again, employmentlawyer.ca, again, employmentlawyer.ca, to connect with me and make sure that we're on the right track, that we have the right strategy. So very, very important to do that. Now, so we talked a bit about wrongful dismissal, again, in between your questions. So the question becomes, how does someone know if they've been wrongfully dismissed? Well, here's the thing. 90% of people, and I'm being conservative, it's probably more than 90%, but let's say 90%. 90% of people, when they've been let go, have been wrongfully dismissed. Why? Because in the vast majority of cases, in almost every case, an employer offers a lot less than what they're actually owed, what the employees actually owed. So if you've been let go, chances are you've been wrongfully dismissed. Whether you work for a month, whether you work for 40 years, whether you're young or old, whether you had a senior position or a junior position, Either way, in the vast majority of cases. And by the way, when I say 90% of people have been wrongfully dismissed, I'm not talking about, well, I was owed 6 months severance and they offered me 5. That's bad enough, right? But I'm talking about a situation where I was owed 6 months severance and they offered me 1. Okay, so happens all the time. We have 50 lawyers across Canada dealing with this. That just tells you how often that happens. Always. Okay, so by the way, we have another tool, and I have a question from Tanya. I'm gonna answer it right now. But one thing to understand, if you want to know the actual amount, we talked about the fact that wrongful dismissal is about severance, right? It's about the right amount of severance. So how do you know how much severance you're actually owed? Well, 2 ways. You can call me and I'll tell you, easy to do, or you can do it yourself. You grab your smartphone, you grab your tablet, and you go to pocketemploymentlawyer.ca. You see that right over here, pocketemploymentlawyer.ca. Why do you go there? Because we have our severance calculator tool there. Severance calculator. What does it do? Well, everything is in the name. It calculates your severance. You answer 3 questions: your age, your position, and the length of your employment, and it tells you how much severance you're owed. Maybe it's 10 months, maybe it's 24 months, maybe it's something else. Easy to use. It's free. It's anonymous. Okay, that's not, there's no strings attached. You don't have to put in any names there. You don't have to put the company's name. It's just there for your benefit. And if you want, you can also contact me directly from that severance calculator. Again, pocketemploymentlawyer.ca. We may as well have called it the wrongful dismissal calculator, because that's what it does. So first place you go to, if you lost your job, if you're worried about losing your job, or maybe you just want to know how much severance is owed to you, pocketemploymentlawyer.ca. Okay, next question today comes from Tanya. Okay, Tanya, I had an FMLA. I'm not sure what that is. After returning, I was informed I'm no longer eligible because I don't meet the 1250 hours required. I'm sorry, I'm not sure exactly what you're referring to, OWCP, so I'm not familiar with those terms. Elaine asks, the location I work at is closing down. We're being sent to different branches. I can't travel to the new location. It is a great distance away from my current location. If I don't accept this transfer, I'm being told I have resigned. Do I have to go along with this? This is a great question, and it goes along with everything we were talking about earlier. So if your employer changes your work location, that can absolutely be a constructive dismissal. So it's not every change that makes that happen. So if the changes, you have to go across the street, clearly that's not going to be a constructive dismissal. So how do you know if the change is a constructive dismissal? Easy. If the new location means you're going to take more than an hour or more to get to work than you did before, we're talking constructive dismissal. So it's not about the distance, it's not about the kilometers, it's about the time. So whether you're taking public transportation, whether you're driving, doesn't matter. If it's going to take you an extra hour, you don't have to accept it. And if they make that change, it's not a resignation, it's a constructive dismissal, meaning you are owed your severance. So I've seen that happen quite a bit over the past few months, certainly since COVID. Employers are relocating. They say, maybe we should have a different location, smaller space, bigger space, and that's fine. But if the individual employee has to now travel more than an extra hour than they did before, no, they don't have to accept it. And if they don't, it's not a resignation. Again, it's a constructive dismissal, meaning you are owed your severance. All right. Great questions today. I love those questions. For those joining us, my name is Lior Samfiru. I'm the employment lawyer here at your service answering questions about employment law. So you can still ask questions, still have some 10 minutes or so to ask those questions. So take advantage. A bunch of questions have come in, so I'm going to answer them right now. Steve on YouTube asks, Lior, what are my rights? I was selected to fill a vacancy as a supervisor. I went for an interview and wasn't selected due to medical reasons and the fact that I didn't complete required assessment on time. So you cannot be refused a promotion or a job, or you can't be discriminated against because of a medical condition. It's one thing to say, well, we needed this assessment from you by February 1st and you didn't give it to us on time. Okay, unless you had a good reason. I was sick, my medical condition didn't allow me, or it took me longer to get to see my doctor. If there's a good reason, they have to work with you. If there's no good reason, then they can make that decision. but they certainly can't say, well, because you have limitations, we're not going to give you the job. So if you think that's what's happening here, Steve, if this is a discrimination case, well, that's a human rights violation. It's not legal. That can also result in a constructive dismissal in addition to that. At that point, you and I need to speak, Steve, okay? You need to connect with me. What we can do is, there'll be two options if we decide that it is a human rights issue. I can get involved and have them rethink their decision, see how fast they react when I get involved. Or if you say, I don't want to work here anymore, I just want to be done, then we can pursue a human rights claim, even a constructive dismissal claim, and get you compensation that way. So to connect with me, Steve, very easy to do. You see that on the screen, employmentlawyer.ca. Again, employmentlawyer.ca. Phone number is there, email address is there. So feel free to use it. Looking forward to connecting. Okay. Next question on YouTube from NA. Okay, we don't know the name. That's okay. I'm still answering the question. NA on YouTube asks, does pay in lieu of notice contribute to severance? If I was offered a week of pay in lieu of notice and I was offered 3 more weeks of pay, is my total severance package 4 weeks? That's exactly what it is. So when we say severance, what we're talking about is the compensation that you get when you lose your job. You can call it severance. You can call it pay in lieu of notice. You can call it termination pay. Compensation that you're paid when you lose your job, the generic term we use is severance. So if you were offered 3 weeks plus 1, that's 4 weeks. So you've been offered 4 weeks. So the real question, NA, is whether 4 weeks is enough. Now, unless you're very young, like teenager, and you work for a very short period of time, like a few weeks or a few months, in a very, very junior position, it's going to be more than 4 weeks. Okay, the severance for most people starts at 3 months. Okay, 2 to 3 months starts at that, and usually is much more than that. So that's how you assess it. And again, for you, NA, for anyone else, if you want to know now, this very moment, how much you're owed, just go to pocketemploymentlawyer.ca, use the severance calculator, and you'll get all the answers. You'll know if 4 weeks is enough. Probably not. And if it's not, you contact me and I'll help you get the severance that you're owed. It's not complicated. Once I get involved, company puts up their hands and say, okay, fine. We'll pay what's owed. Okay. So that's why you have my contact information. Again, employmentlawyer.ca. Okay, let's see. I just want to make sure I haven't missed anything here. From Steve, I think Steve has a follow-up here. They slapped me with a disciplinary action and then had me apply for the second in command and then put someone else in it without me knowing. Is that a constructive dismissal? So let's see. They put disciplinary action and then had me apply for the second in command. So I'm not sure exactly I understand what they did. If they disciplined you when it's not justified, if they make stuff up, of course that's not allowed. That could easily be a constructive dismissal. If they're picking on you because of a medical condition, not allowed. Human rights violation and a constructive dismissal, right? So keep those things in mind. But as I said before, Steve, you probably want to connect with me. Again, probably want to connect with me sooner rather than later. By the way, that's a very important point. If you think your situation is a constructive dismissal, you cannot sit on it. You cannot wait. It needs to be dealt with right away. Because if you don't do anything, you're considered to have accepted whatever it is that your employer did. And then you're stuck. Okay? Don't let that happen. So if your employer did something, mistreated you, changed your job, your pay, your compensation, give me a call. Okay? Don't wait. Sometimes even waiting a few weeks is too late. Okay, very important. Employmentlawyer.ca to connect with me. Okay, next question from SMB 0121. I've been employed with the company for 1.5 years and had a family emergency, death of an immediate family member. I had the sufficient leave balance, and my company gave me a termination letter. Well, obviously, we need to talk about that because there could be a breach of the Employment Standards Act there. There could be a human rights violation depending on the situation. And I bet you anything that even if they offered you severance, you're owed much more severance than what they've offered you. So there's a bunch of stuff here that we need to talk about. All right. So you need to connect with me so that I can assess your matter. You certainly would never be caused to be let go. And you do have rights to take leave under employment standards. And you're also under human rights, depending on who passed away. If it was a parent or a child, there could be a discrimination based on family status. So there's a number of things here that we should be talking about. So SMB 0121, you really want to connect with me ASAP, okay? ASAP. At a minimum, even if the termination itself was legal, it's not, but even if it was, there's still the issue of severance. And remember what I said a few minutes ago, then almost everyone, over 90% of people, when they're let go, even if the reason is legal, they're owed a lot more severance than what they've been offered. Okay, so that's why you need to connect with me as soon as possible. All right, Bobby Dillon on YouTube says, can you file? Can you get a severance? Can you get severance and still file a human rights complaint? Yes, but usually we don't need to do it separately. We can deal with both issues together. But yes, it's possible, but oftentimes we don't need to. That's why even the idea of you trying to do it on your own, honestly, silly, wrong. You got to have proper representation. You don't like me? That's okay. Speak to someone else. But trying to do it on your own makes no sense. Okay, you want to reach out as soon as possible. And if you do want to connect with me, again, employmentlawyer.ca, employmentlawyer.ca. I told you guys, a bunch of questions are going to come at the end. I'm going to try my best to get through them. Matt on YouTube asks, I worked for a company just under 2 years ago. I worked for them for around 5 to 6 months, working 20 hours a day. 20 hours a day, holy cow. I developed some health issues and was let go without explanation with no severance. Well, I'm hoping that no one needs to be an employment law expert to know that that's not legal. It's not allowed, not even close. Number one, to have you work 20 hours a day, just that is illegal. But let's put that aside. Even if you work, you said 5 to 6 months, even then you're owed severance of several months, not days, not weeks. So even though you worked for them for 6 months, you could be owed 3, 4, 5, 6 months of severance, months, not weeks. Beyond that, if you have a medical condition and then they let you go, that's a human rights violation. Can't do that. And if the medical and the health issues were because of work, that could also be a violation of workers' comp legislation. So very, very wrong, very illegal, everything that you've just described to me, Matt. Now, you said this was under 2 years ago. That's the good news. The good news is that there's a 2-year limitation period. So if it's been under 2 years, you can still do something about it. If it was 2 years or over, you'd be out of time. So I don't want to be in a situation where we're under the gun. Call me ASAP, okay? Employmentlawyer.ca for all the contact information. Let's connect. Let's do this right. So let's see. NA says, I was initially offered 2 weeks, but I was able to negotiate 3 more weeks of pay for a total of 5 weeks. Is that the wrong strategy, or can a lawyer still negotiate for me if they increase? Well, if you already told them that you'll accept 5 weeks, it's too late. But is a lawyer going to be able to do better than that? Absolutely. Okay, always. That's what we do for a living. It's like saying, is a doctor going to be able to treat me better than I can treat myself? Well, I think the answer is obvious. So absolutely. But if you already said, yeah, I'll accept 5 weeks, then you can't go back, even if you haven't signed anything. If you told them, yes, I'll take it, or we have a deal, unfortunately, you're stuck at that point. So I think I'm caught up on these questions, guys. Excellent questions today. Really, really, really good questions. That's why I do the session. So thank you for doing that. And again, to continue the conversation, to follow up with me, to learn more, easy. Just go to employmentlawyer.ca. You can contact me through there if you want to. You can learn more about employment law. You can learn more when myself and my colleagues are back here on social media doing these sessions for you at your benefits. But if you have an issue, don't wait till the next time. Contact me today. Again, employmentlawyer.ca. Great questions again, guys. Thank you so much for joining me. Really a pleasure to be here. Always is. Happy New Year again to all of you. I'll be back. I'll see you soon. And thanks. Take care.